Good afternoon and welcome to our panel. Thank you everyone for joining us. My name is Ertuğ Tombuş. I'm a research associate at the Humboldt-University in Berlin and at the Center for Comparative Research on Democracy. Today's panel is the first panel of our panel series, Human Rights and the Rule of Law in Turkey, which is co-organized by the Law and Society Institute and the Center for Comparative Research on Democracy at HU Berlin. Law and Society Institute is one of the 4 integrative research institutes at Humboldt. LSI's main aim is to support interdisciplinary and innovative legal research and cross-faculty cooperation. LSI also cooperates with national and international partners. Center for Comparative Research on Democracy is a newly established center at Humboldt. CCRD is funded by the Einstein Foundation Berlin and Mercator Foundation. The center's main aim is to conduct and promote interdisciplinary and comparative research on democracy, Einstein Fellows Research Group, Einstein Research Project on Judicial Autonomy, Academic Freedom Network, and Contemporary Turkey Studies Program are the main pillars of the center. The center is part of Professor Sylvia von Steinsdorf Chair, Comparative Political Science and Political Systems of Eastern Europe at the Institute of Social Sciences at HU Berlin. Our webpage will be ready soon, so before going to the basic rules of the panel, I would like to thank all the team members of the Law and Society Institute and the CCRD. A couple of reminders about the logistics of tonight, that your cameras and videos will be is disabled and will stay disabled tonight, and we ask you to write your questions on the chat box, and Esra and I will address your questions to our guests. The session is being recorded. Before giving floor to Esra, who is my co-convener in this panel series, Esra Demir is an Alexander von Humboldt Fellow at Humboldt-University Faculty of Law. After receiving her LLM in Public Law from Istanbul University and MA in Human Rights from the University of Essex, she obtained her PhD in Public Law from Marmara University. Previously, Esra worked at the Departments of Human Rights Law and Public Law at Marmara University, Istanbul. Between 2017 and 2020, she held visiting positions at Freie University Berlin, Hertie School of Governance. Her main research interests involve human rights law, the history of international law, gender, and liberal legalism. So to introduce our guests and start the session, I'll leave the floor to Esra.
Thank you, Ertuğ. Today we will discuss Turkey's State of Emergency Inquiry Commission with 2 legal experts, Ayşe Demir and Dr. Kerem Altıparmak. Ayşe is joining us today from New York and Kerem is joining us from Ankara. Let me briefly introduce them. Ayşe Demir is a lawyer specialized in international human rights law and domestic law and procedures in Turkey. She is a graduate of Istanbul University Law Faculty and Queen's Mary University of London, where she obtained an LLM in human rights law. Ayşe practiced in Istanbul between 2003 and 2017 and was particularly involved in cases concerning serious violations of human rights. Ayşe was awarded the 2016 CCBE Human Rights Award jointly with 3 other lawyers from Turkey. She previously worked with Media Legal Defense Initiative. She was a research fellow with Middlesex University School of Law until 2020. She was part of the group of experts that conceived of the London-based Turkey Human Rights Litigation Support Project and has been acting as its co-director since the beginning of the project in January 2018. Currently based in New York, she also works as a nonprofit consultant and country expert for several national and international civil society organizations. And our second speaker, Kerem Altıparmak, is currently the chair of the Ankara Bar Association Human Rights Center and deputy chair of the Human Rights Association. He also serves as a legal consultant to the International Commission of Jurists. Kerem has LLB and LLM degrees from Ankara University and PhD degree from the University of Leeds. He was the director of the Human Rights Center of Ankara University, Faculty of Political Sciences, until October 2017. He has worked in a number of human rights projects, especially with the Human Rights Joint Platform in Turkey. He won Turkish Publishers Association Award, Halit Çelenk Legal Prize, Columbia Global Freedom of Expression Award, and Press Association of Turkey Freedom Prize with another law professor from Turkey. He was also the recipient of Franco-German Prize for Human Rights and the Rule of Law in 2017. Thank you, Kerem and Ayşe, for accepting our invitation to join this panel.
Thank you. And hello to everyone. I see names.
Thank you.
Yes, this is, I think, the new problem of our generation, right? So before we go into the details of the State of Emergency Inquiry Commission as the main topic of today's panel, I would like to ask, as also a background information, what happened during the state of emergency, especially regarding the emergency legislative decrees, and why is there a State of Emergency Inquiry Commission even is still in place more than 2.5 years after the lifting of the state of emergency. We can maybe start with Kerem. And
okay, I mean, this new way of dismissing public servants, I'm saying new because it was new even for Turkey when it was taken, and people were dismissed by emergency decrees. And although this is a decree, this has the force of law in Turkey. And after dismissals, those who were dismissed tried to find a way to challenge the decision. Some of them apply to the administrative courts. And more than 300 cases that I could see coming from administrative courts stated that although emergency decrees are issued by the executive branch, they cannot be the subject of judicial review by administrative courts since they function as laws. So we have practically administrative decisions taken in the shape of legislative action. So during state of emergency decrees cannot be brought to constitutional courts, although it's also questionable because previously the constitutional court ruled that if the emergency decree is not related to the emergency, then it can review and annul those decrees. However, after coup attempt that took place in 2016, the Constitutional Court radically changed this case law and decided that there is no way that it could review state of emergency decrees. So that way was closed, and administrative courts also stated that these were acts of legislation or function as a law, so they cannot be seen as administrative actions. There was no way to go. People tried to apply to the Constitutional Court or European Court of Human Rights, or they applied both of them. And you might remember in Zihni versus Turkey, the European Court found the application inadmissible on the ground that not all local remedies were exhausted. But for a very long period, the Constitutional Court did not examine those applications. During this legal crisis, Secretary General of the Council of Europe, Jagland, was traveling to Turkey, playing the arbitration role between Turkey and the Council of Europe and the European Court of Human Rights. And Venice Commission released a report about dismissals and state of emergency decrees. As a result of this shuttle diplomacy, the government decided to establish states of emergency inquiry commission because otherwise the European Court of Human Rights had to examine and decide in dismissal cases. To prevent this, to avoid this risk, the government accepted to establish this emergency inquiry commission. So I mean, it's odd because we have a legal document which has the power of law, but an administrative commission is reviewing whether it's in line with constitution or other laws or not. So while on the one hand, the Constitutional Court says that I cannot review them, an administrative body was empowered to review them. And after the end of state of emergency, CHP, the main opposition party, brought those decrees to the Constitutional Court. But the Constitutional Court has not decided yet about the constitutionality of this dismissal decrees. So we will see how it's gonna overcome this legal limbo in that decision. But this was the reason for the establishment of State of Emergency Inquiry Commission.
Yeah. You want to add something, Ayşe?
No, Kerem actually covered the question quite widely, but I think that it's as he explained, it's really important to underline that that this establishment of the State of Emergency Inquiry Commission was somehow a result of that diplomacy between the European Council and Turkey. But while doing that, Turkey took this move of establishing the commission without actually taking into account the direction given to Turkey by those organs. For example, Venice Commission in its evaluation in relation to compatibility of the decree, state of emergency decree laws with international law, made a detailed assessment of why the decree laws were extremely problematic. And while defining that there was no effective remedy provided to those dismissed under the state of emergency, the Venice Commission recommended Turkey to ensure that an effective remedy is in place. It also defined some criteria that Turkey should take into account in doing so. And that is to be ensuring independence and impartiality of that remedy, ensuring a timely response to those violations that took place against the public service workers, ensuring that their fair trial rights, procedural rights are protected in the process, and so on and so forth. And I think that the extreme undermining of this didn't only come from Turkey, it also came from the European Court of Human Rights too, while finding the Commission as an effective remedy in Köksal judgment, the European Court also didn't assess whether Turkey took into account while establishing that criteria. And I think maybe we will discuss our criticism towards the Commission and the way its functions and other aspects of it. I think it's important to say that move of Turkey was not actually to provide an effective remedy internally, but to prevent those cases to be brought before the international avenues, in a way blocking those cases to be heard by an effective procedure, international procedure.
Can you also give idea about the severity of the issue and the scope of the people affected by it? The state of emergency, during the state of emergency decrees, because the declaration of the state of emergency and the measures that are supposedly taken within the framework needs to be, at least even in Turkish constitution, should be limited in terms of the scope of whatever the danger is, and so in that sense, the decrees are these decrees targeting, as the government says, directly and clearly to those who involved in the coup attempt, or it is kind of wider than that, and it's kind of instrumentalized in a different way.
Is it to me, the question? Obviously, I think there is a wide agreement on two sides of this discussion. One, from the international law perspective, like including the European Court of Human Rights and the UN human rights monitoring bodies, they kind of agreed that Turkey's declaration of the state of emergency reflected on the criteria required by under what circumstances such a declaration can be made. So there was a coup attempt. It was a serious event, and it under the international law, those institutions agreed that it imposed a threat to the national security or the existence of the system in the country. But there's also a wide agreement that Turkish government used that situation as a leverage to further its agenda. So the declaration of state of emergency was made in July 2016, and it lasted for 2 years, meaning that and under the international law, that state of emergency could remain in place until that danger, as long as the danger is there, and to respond to for the reason to respond to that danger, and within the limits of the that necessitates the measures under the state of emergency should remain strictly necessary and proportionate by the reason that that declaration was made. So the fact that the state of emergency was declared as a result of the coup attempt, all the state of emergency measures should have been strictly limited to that coup attempt, to resolve that issue within the system, and the measures taken should be temporary, and it should exist as long as that threat existed, that is to say. But as we know, the dismissals are the kind of one of the most serious aspect of what happened during the state of emergency. And the reason for that, as we know, we are talking about dismissal of more than 100,000 public sector workers. When I was going through the documents in relation to dismissals, I saw once more time that the way the government presents it is based on the argument that those people were dismissed because they were allegedly linked to Gülenists, and they were dismissed because of that. But this is not the case. Many other people having no link at all with Gülenists, or not, the accusations, the allegations against them is not because they were Gülenists too. It's because their criticism to the government, their progressive approach, their opposition to the government, or their position to be perceived opponents to the government, or being trade unionist or so. So the government used the state of emergency to be able to, in their own terms, clean the state institutions from those who are not supporting the current government, their political agenda or purpose to adopt their own agenda easily. And I am not saying that based on a political approach or so, this is just the facts. When you analyze the people who have been dismissed, this applications made to the commission and the cases brought before the relevant institutions, it's obvious that not only people who are allegedly linked to the coup or Gülenists have been affected by the emergency measures. Many other people, including academics for peace who signed the peace declaration, also have been made subject of this. So I think that there is an agreement that Turkey used the coup attempt and state of emergency to bring Turkey where it is right now.
Can I add something about figures? On the morning of coup attempt, in less than 12 hours, 2,750 judges and prosecutors were suspended. And to the best of my knowledge, none of them has been accused for taking guns to their hands to get involved in the coup attempt. And in the first state of emergency decree that dismissed more than 50,000 public servants on 1st of September, it was just a month and a half later after the coup attempt, and there's no explanation how in such a short time the government officials could find the persons who are connected to the coup attempt. And even in that decree, there were peace petitioners, because from Ankara University, I know that there were peace petitioners listed in the September 2016 decree. So it shows us that the government has already had a list at their hands. And after then, when you read, as you know, judges and prosecutors are not amongst the public servants that were dismissed by decrees. They were dismissed by the decision of Judges and Prosecutors Board. But when you read the decision of the Judges and Prosecutors Board, the link between the acts of judges and prosecutors who were dismissed and the coup is not visible. I mean, they say something about a couple of decisions which allegedly taken by Gülenist judges and prosecutors. But even if we accept that this is an evidence to dismiss some judges and prosecutors, those decisions do not explain why the judges and prosecutors listed in the decision could be linked to the decisions narrated in the judges and prosecutors board's decision, or we can call it decree as well. So that it is obvious that, and after then, the government never tried to create a link between dismissals and the coup attempt. On the contrary, we will come to this point, I guess. Those who have been acquitted or never been prosecuted still rejected by the commission. So it's clear that there were no criminal acts of those people, but they still were dismissed. And the commission explained this with the distinction of criminal act and an act that deserves dismissal. So, I mean, if we limit this to those who got involved in the coup attempt, it's obvious that all of them should be labeled as criminals, not those who deserve to be dismissed. So even this logic behind the decision of commission explains that not only those who involved in the coup attempt, but many others were also targeted by state of emergency decrees.
Thank you very much, Kerem. Now, I also want to ask a question to provide some more background before discussing more about the commission. Could you please explain us why these dismissals that were carried out by state of emergency decrees are sometimes called as civil death? What makes them something akin to a civil death? Maybe we can start with Kerem again.
I mean, we call it civil death because, first of all, the periods, consequences are very wide, first of all. For instance, I mean, you know better than all of us, I guess, a dismissed university professor cannot be employed in a private university. For lawyers, until the judgment of the Constitutional Court, they couldn't register as an attorney in bar associations. And when dismissed public servants are recruited by private companies, they were seen in the social security system as a dismissed public servant. So, I mean, there was a kind of stigmatization. Plus, unlike other lustration examples, there was no time limit for this dismissals. In other words, you are stigmatized, you have no chance to find a job in public service, and opportunities in private sector is extremely limited. And it really forced a lot of people to kind of civil debts, because not only they were not only dismissed from a public service, but all their private life has been affected severely by these dismissals. We will come to this point. I think that very point was missed by the court in the Pishkin judgments by the European Court of Human Rights, because the impact of dismissal was very similar to a conviction delivered by a criminal court. Because, I mean, if you get a conviction for more than 1 year imprisonment at a criminal court, then you cannot be recruited as a public servant. And this continues for life. There are a lot of similarities between the consequences of conviction and dismissals. That's why I think some people use, and I might be one of the first that used this term, by the way, civil debts. And then Parliamentary Assembly used in its decision about Turkey, and it called this as civil debt. But as I stated, unfortunately, the European Court did not see this aspect of dismissals.
Thank you very much. Would you like to add something to that, Ayşe?
No, it's a term, unfortunately, it's in the consequences of dismissals. What for their jobs, their passports also were cancelled. In a way, their chances to leave the country or going to another country and start a new life there was also prevented in practice. And for example, in the Kurdish region, it affected, used as a tool to not to grant the elected mayors their seats those who were dismissed from under the state of emergency decrees, their mayorship were not recognized because based on that, even after they were elected. So it was an action. It has been an action that became permanent and affect all aspects of lives of people, preventing them to provide for themselves and their families even with their basic needs, including healthcare, social security, retirement rights. So it affected every aspect of their lives, and this is why this term has been used for that situation.
Thank you very much, Ayşe. You also mentioned the incompatibility of the Commission, the establishment of the Commission with the Venice Commission's recommendations, but maybe we can explain this a little bit more. For instance, among those recommendations by the Venice Commission, there were the need to establish a body that has sufficient safeguards to act independently and impartially, and also to work in line with the due procedure safeguards. Do you think that the established commission comply with these certain recommendations of the Venice Commission?
So I think
again, Ayşe, and then maybe
I think that first of all, the fact that Turkey was somehow directed to establish something new was very problematic, because as Kerem described, there were some, of course, there was this confusion due to the practices of Constitutional Court, Administrative Court, Council of State. But there were legal procedures in place that would allow the courts to determine those cases right after the declaration of the state of emergency. By that I mean that the European Council or the other international organs, they could have just forced try to put pressure on Turkey to facilitate those remedies that were already existed in Turkey. Like, for example, the administrative courts should have heard those cases, or the Constitutional Court or the Council of State should have heard the cases. There was no reason to put something new in front of all these procedures to make this process more difficult or not bearable for the people. And what we see right now shows that it didn't. Turkey used it to actually prevent those cases to be properly heard. And that was the first mistake, I would say, made in the beginning of this process. Also, when Turkey was in the process of establishing the commission, I think there was no enough pressure again on the way the commission was established. It was established by a decree law in January 2017, but started functioning, I think, in May 2017. And there are lots of aspects that are problematic about the way the commission was established and the way it functioned afterwards. For example, there are 7 members of the commission. 5 of them are being appointed directly by the president, Minister of Interior, Minister of Justice. 2 of them are appointed by the Council of Judges and Prosecutors, independent and impartiality of which is highly questionable too. So meaning that the constitution of the commission does not provide that guarantee of impartiality and independence. And also the way the procedure was defined for the commission, the way the applications are received, the way they are evaluated, the way they are concluded, the time they are being processed by the commission, they are all problematic. No safeguards are placed, no due process rights are respected. It's not possible. It's not possible for people to effectively know know why they were dismissed during this process, or what actions the Commission is taking to consider their application, and they are not being heard in person. There is no possibility for them to defend themselves in person. So the problematic aspect of, another problematic aspect in relation to that is oversight mechanisms seem to say that the Commission is an administrative body, it's not a court. So those certain safeguards don't need to exist there, but the fact that the decision of the Commission is open for review of administrative court review or the constitutional court review, then would place those safeguards in the process, which is again problematic, because when you don't let those people, that don't respect the dismissed people rights from the beginning of the process, where you will start to fix it, how you are going to do that also. So there are lots of other problematic aspects of the way the Commission was established, the way it has been functioning, but very generally, I think I could just mention those.
Kerem, would you like to add something?
Yes, a couple of things. First of all, I mean, we need to understand what this body is doing. I mean, they examine the decisions of administration, and they decide whether that's in line with law or not. This is functionally a judicial work. So 7 members, as Ayşe stated, 5 of them are public servants appointed by Prime Minister at that time and ministers, were supposed to decide in more than 100,000 cases. It was obvious that it was not possible to do in 2 years' time. Even in 10 years' time, 7 people cannot decide in 100,000 cases. So although there are 7 persons signing those documents, we know that, in fact, these decisions are not taken by those 7 individuals. The Secretariat of the Commission is composed of public servants appointed by administrative body. So judicial decisions are taken by public servants who are hierarchically linked to the bodies who already decided to dismiss those people. So this is odd. Secondly, if we assume that that all members would be loyal, but if not, if just one of them is not loyal enough, what happens? The law also states this. It says that a member shall be dismissed by the Commission if it is found that an administrative investigation was launched or authorization was given to start an investigation by the Prime Ministry against a member on grounds of membership, association, connection, or contact with terrorist organizations. So an administrative investigation initiated by Prime Ministry is enough to dismiss the members of the Commission. So it's clear that if a member of the Commission challenges the decision already taken by the administrative bodies, might find him or herself in danger, similar danger with the people that the Commission examines the application. So there is no explanation why, because legally, and you might say that, okay, these are not administrative acts, this is a decree, that's why courts cannot examine this. But if it's the fact, then how can an administrative body can examine a decision of the parliament or a legislative functioning administrative decision, let's say? If a court can't do it, then an administrative body shouldn't do the same thing. that's why I think instead of forcing the Turkish government to create a administrative body, the Council of Europe authorities should have put pressure on the Turkish government to open courts to review the decisions of dismissals. That was the right thing. I mean, this is only delaying the process. We still don't have a judgment from Council of State about dismissals. And some dismissed public servants still are waiting for a decision from the Commission. And we don't know how long it will take. So this Commission has not solved problems. It only extended the periods that dismissed public servants had to spend before public authorities. So neither the functioning of the Commission nor the composition of it was in line with the decisions of the Venice Commission.
Thank you very much. But before maybe discussing more about it as actual practice, we can also talk a little bit about the individual's petitions to the Commission, because I would like to ask this to Ayşe, because Turkey Litigation Support Team's report examines also the individual's petitions. Without knowing the concrete grounds for their dismissals, how could they defend themselves? How did they formulate their arguments while appealing the decisions of their dismissal?
It was, from our research on the effectiveness of the State of Emergency Inquiry Commission, we did analyze the petitions made by the applicants to the Commission to see whether how they dealt with that situation. It's literally trying to just guessing, trying to understand, and from the information accessible through open sources like online, what they hear from the press or so, to try to conclude, kind of guess why they might have been dismissed, and trying to reflect on that based on that. So in the applications to the commissions, for some groups, it's a mere act of trying to establish that they did not, for Gülenist related issues, they did not have any account with Bank S, Asya. They did not send their kids to the educational institutions of Gülenist, or they were not registered for any Gülenist institutions, unions, or they did not work in any of the Gülenist allegedly affiliated institutions. Also a mere act of trying to guess and defend themselves based on what they think that it might be. And for the others who don't have any that Gülenist side of the thing, again, they try to say that they had no problem that they would be assumed to be linked to or have any affiliation with the proscribed groups. And this is not only in relation to the application process. For example, once the application is made to the Commission and it is processed, the Commission does gathers lots of information from different state institutions on those people. And those information are not communicated to the applicants to give them the opportunity to understand what information was gathered and reply to them and submit their defenses or share their views on those, so that the Commission would have we speak about equality of arms principle. We discussed that the right to be able to defend themselves in the process or present their arguments effectively before a procedure. This is not respected because the people are not also communicated that information collected by the commission too. So it's based on that, our conclusion was this was one of the very serious aspects, failure of the commission in the process, because it does not give the applicants any way to effectively put forward their arguments or put forward their counter-arguments against the information available to the commission.
Thank you very much, Ayşe. Then how does the commission make its decisions based on what kind of information and evidence, and how does it gather those evidences or information? Maybe we can ask this time to Kerem.
Esra, the decrees, says that individuals were dismissed on grounds of membership, association, connection, or contact with terrorist organization or bodies, entities or groups which are decided by the National Security Council to have acted against the national security of the state. However, no information has been given to them as to which bodies, entities, or groups they are alleged to be involved in, or which behavior constitute the connection or contact. So even now we don't know what is connection, what is contacts, what is membership, what is association, what are the differences between these four concepts. So when you're dismissed, if you don't know for which group or entity you are dismissed, first of all, you have to assume that you might be connected to one of them. So it's against very principle of prohibition of a person accusation him or herself. So, I mean, you should first assume that you're guilty for doing or for acting with a certain group. Then you will try to refute this, or you will take the list of all organizations found by the National Security Council to have acted against the national security. Then one by one, you eliminate them. I'm not member to DHKPC, I'm not member to PKK, I'm not member to FETÖ, kind of thing. So obviously this is not possible. So some people said that I have nothing to do with any kind of organization. I think that was the best strategy because otherwise it was like giving a clue to the authorities. Secondly, some people said that I have no connection to this organization, assuming that, I mean, that might be the case. In any case, this is not fair. I mean, this is apart from equality of arms principle. As I stated, you have to first assume a crime and then you refute it, and this is old. We don't know how and from which institutions the commission obtain evidence, but the main source of evidence is the public administration that dismisses the individual. It provides the information. And from the very beginning of the process, the Constitutional Court paved the way for this. When it dismissed two members of the Constitutional Court, it stated that social environment information is enough to dismiss a public servant. So when you open the way in this way, any kind of evidence, even a gossip made between public servants, might work as an evidence to dismiss a public servant. So the commission started with the easy cases, by the way, where they found bylaw use of public servants, or when they had bankasya accounts and others. But in many other examples, especially in the final decisions, we see more and more this environment, social environment information thing as the main evidence. There is no other, there's no other evidence to prove this, and just this information is being found sufficient to decide against the individual. So I think this is the general picture about the functioning of the commission.
Ayşe,
may I add few things on based on our report, the research we carried out in the course of our report. We had the chance to analyze quite a bit of numbers of commission's decisions, and there, as Kerem stated, there are, I think that a division could be made between those who are allegedly somehow have some links with Gülenist and those who are not, like the others, including, for example, like the PKK related accusations or the DHKPC related accusations. So what the commission does, it seems like that there's some sort of template they apply. They check for Gülenist related ones. They check the Bank Asya records. They check Gülenist the institutions that were closed under the decree laws to be affiliated with Gülenist, whether those people have any links to those institutions, they work there, whether they had any financial relationships with them, their educational institutions or so. So if one of them is found, it's most likely that their applications will be rejected. And in relation to others, I would say, what Kerem said reflects on the reality. It's based on social environment research or information they gather from the institutions those people worked within, or the notes received from their superiors, from their colleagues. There are secret witnesses. For example, we saw that there is a secret witness called Albatros who kind of provided a list of thousands of people, and the commission took into account that so. And intelligence reports that they refer some information as intelligence reports, and information notes from the governors or so. So all this is based on, as Kerem said, without any safeguard, without knowing who is accused making that allegation, without knowing the basis of it. A little note saying that person is linked to this organization is enough for the commission to reject the applications. The commission also looks into whether there is any criminal investigation against those people, and some information on what happens in the course of those investigations. But even in the cases where the criminal investigations were closed without any further step, whether the accusations were dropped, or even when there's an acquittal decision, those people are still not returned to their position if there is a note that, as I mentioned, against them saying that they are affiliated. And the commission kind of reasons this based on that that they are not carrying out a criminal process. It's the question of loyalty of the state, and the state has discretion in deciding it. If there is a note, there is an indication of that person is linked to a proscribed group, then the state has the right to say that they are not going to work with it. And as Kerem mentioned, this is an approach that adopted by the Constitutional Court also. And it's actually directly reflects on the institutions who actually dismiss those people, saying, based on the fact that they don't think they are loyal enough to the state to continue their employment. So yeah, the procedure before the commission is highly problematic. I am sure that many people know it. Like more than 120,000 applications were made to the commission. The commission concluded around more than 110,000 of it, and accepted accepted only 13,000 of it, which is a little above 10%, meaning that around 90% of the applications before the commission have been rejected. And the practice of the administrative court also showed that it decides in line with the commission's perception, meaning that those how many years in? Almost 5 years in from the first dismissals, these people are still looking into ways to get a proper decision from an institution, and it's not there yet.
Thank you very much, Ayşe. There are also some 14,000 individuals who are still awaiting a decision from the commission. They are still at the first stage of this journey in domestic remedies. And in 2009, the chair of the commission was reportedly said that the files that remain unexamined are those that are not easy to make a decision on. Actually, Kerem also mentioned that the easy files were concluded first. But is it true? I mean, given the fact that those 14,000 applications include also, for instance, the applications from Academics for Peace, what does the chair of the commission mean by difficult files, I mean, or files that are difficult to come to a decision about?
I mean, I think one of the things that we should remember is that what is the priority policy of this commission? First come, first based, most important cases, high-level public officials versus low-level public officials. I mean, we don't know. That's why there are people who already received decisions, although they were dismissed in the last degree, whilst those others waiting from the first degree a decision from the commission. So this is not clear. Secondly, as we already stated, I mean, if we talk about 14,000 cases, and if they are difficult, how quick 7 people can decide about them? 1,000 per month. So it will mean that 20 working days, every day they have to finish this difficult cases, 50 difficult cases per day. If they work in this way, it will still take another 14 months to finish the business they have. So from what I understand, when they call it difficult, either it's not a copy-paste type of decision, they can be separated from other applications for a reason. Maybe there is no evidence from the bank account or membership to trade union or not a petitioner and so on. That might be a reason. The second one is those files require a close examination. In that case, as I stated, you cannot finish 14,000 cases in a year. You need another 10 years to finish them. And thirdly, this is the, I think, most plausible explanation, is the most sensitive politically cases. This is the difficulty. Because, I mean, about peace petitioners, if they treat all peace petitioners on equal foot, then they will just give one decision and then decide in 400 cases. This is not difficult. But I mean, if there is a decision to examine them one by one, rather than dismissing all applications, picking some leaders, let's say, amongst the peace petitioners, then of course you need time to go through all those applications. This was not the case about other applications, other dismissals, but it might be the case for the remainder. That's why he might be saying that now, from now on, these are difficult cases. For the last 10,000 cases, we will be really examining them one by one. So it's a kind of confession that so far they automatically accepted what was presented by the administrative authorities. But from now on, for the remaining little part of cases, they will examine them. I think this is the explanation what we have, and now we have less than 10 months to finish the business, but I guess now the number is less than 14,000. By the way, I heard some people receive decisions in the last 2 months, so we might have around 10,000 remaining, and we will come to other cases. By the way, not all of them are dismissals. A lot of decision to close association companies and so on, and they should be more difficult than individual cases. And I really suspect whether this commission will be able to finish its work until the end of the year. And I want to add one thing, apart from the commission's work, we will come to this, but I think still we can talk a little bit on this. I think the Council of State should have delivered a principal case much earlier than now, because we still don't know which acts can be seen as a connection, association, or membership. So they left this to be decided by the commission, but this should have been defined by the highest administrative court. Then the commission should have implemented these principal decisions to the cases it has had. But now its work will end, and the Supreme Administrative Court will decide, but no administrative body to implement this principle will be available. So I think this is one of the main problems. I mean, even if we accept that this is properly working, this is fair, still there are serious problems. Considering that neither the European Court nor the Constitutional Court gave a definition about the concept, Council of State was the only institution that could do so, and it didn't. So this has become a very arbitrary procedure conducted by a commission, which is not a judicial body, and it hasn't been corrected by the administrative courts on the other hand.
And then the question will be about the judicial review of these decisions. You already mentioned about its weaknesses, but still, I mean, we know very little about what is going on before the administrative courts that are reviewing the commission's decisions, because there's no comprehensive report, anything to my knowledge. Actually, there's nothing yet published on that, but we hear some very negative stories about that. What could you share about the judicial review of the commission's decisions, whether it is capable of correcting the deficiencies of the commission's decisions?
I can comment on that briefly. When we were carrying out our research, we also had difficulty to access decisions from the administrative court. So we couldn't kind of write or work on that aspect of it. But I think we can mention two important matters that we don't have to see the decisions, but puts questions on this process from the outset. One is that the administrative courts are to be heard. The challenges to the Commission decisions are designated by the Council of Judges and Prosecutor. They can only be specific courts in Ankara administrative courts jurisdiction. And the numbers of them are being named, identified by the Council of Judges and Prosecutor. And this, we think, that is against the principle of natural judge, again, principle of the court to be heard, you not being defined by an institution, independence and impartiality of which is questioned, as we discussed. Another aspect of this is that the administrative court doesn't have competency to correct the decision of the Commission, in a sense that it's for a remedy to be effective, there has to be it has to provide a prospect of success, and it has to remedy the violation, right? Or that whatever wrong was doing against that person. But in this case, the administrative courts are not competent to do that. They can just formally review the Commission's decision and say whether the Commission's decision was made in line with the competence of the Commission or not. In that sense, the administrative court remedy is not a remedy in a sense that we would expect it to provide a redress. And also, once a decision is made to say that the Commission's decision was not in line with the law, in that case, to be able to put that person in the position before the violation took place. This is the case for the Commission also. When the Commission accepts the application, that person cannot directly go and start working from where they have been dismissed. There is another process should be followed, and where that person could go to work, and so will this be decided again. And in certain cases, for example, for academics, they cannot return to the universities they were dismissed from, but they can only be returned to there are some limitations. They cannot be returned to a university in Ankara, Izmir, Istanbul. It has to be an institution established after a certain time. So in a way, the problematic aspects are not just related to the procedure, it's also related to, even when you get a decision from the Commission and then maybe from the administrative court, what happens after that? Whether your situation is that violation is being remedied or not. And I think that from that sense, administrative court's effectiveness could also be challenged, should also be challenged, regardless of how they process the application, as we talked, indication of which show that the similar problems we see from the Commission side is continuing at administrative court side too.
Thank you very much. Kerem, would you like to add to Ayşe something about the judicial review?
I think, I can go with judicial review before the Constitutional Court, maybe, because it's critical, and maybe the European Court as well. First of all, the Constitutional Court visited the foreseeability of decrease, the definition of this link to terrorist organization or affiliated with thing not in an individual complaint mechanism case, but in an annulment case. It was about notary law. This is a part of civil debts discussion because as in many other laws, they also added a provision into notary law, which prevented dismissed public servants to be notaries. And in that case, the Constitutional Court examined whether this new definition was foreseeable. And as the European Court did in Pishkin versus Turkey, they treated this new provision as if it was available at the date of dismissal. They didn't discuss the retroactive application of the provision, because until 2016 September, we never heard this in Turkish iltisak irtibat affiliated or linked with the organization. So it was firstly used at that time. And as I already stated, it is still not known by Turkish lawyer what they mean. But the Constitutional Court in this notary law judgment, and then the European Court in Pishkin stated that, okay, this is foreseeable, and as every law, it's open for interpretation. So by interpretation, it might be clarified. However, the problem was not that it was foreseeable, available at the date of dismissal. So you cannot assume that at one point the government will enact a law that might be implemented to your pastime acts and deeds. So the Constitutional Court closed the door to the allegations that it was not foreseeable. Secondly, the Constitutional Court and the European Court obviously do not see this measure as a criminal sanction. I had a note on this, but anyway, the Constitutional Court and Council of State think that this is an exceptional administrative sanction, not an administrative act, not a criminal sanction, but extraordinary measure only taken under state of emergency. I mean, legally, what does it mean? I don't know, because it doesn't mean a lot to a lawyer, because if it's an administrative act, you challenge it before the administrative courts. If it's a criminal sanction, you have the rights to defend yourself before criminal courts. But what does it mean saying that this is an extraordinary measure taken during state of emergency is not known. So I think we shouldn't be very positive about what we can get from the Constitutional Court and the European Court, because it means that in every case, one by one, they will examine whether the authorities provide sufficient evidence to dismiss that public servant. So considering that the procedures before Turkish authorities will continue for around 15 to 20 years, then I mean, without having a principled decision from the Constitutional Court and European Court of Human Rights, it might take up to 20 to 25 years for an individual to get a justice from Strasbourg Court. And that's why I believe that neither the Pishkin judgment nor the Constitutional Court's decisions about labor disputes, because in a number of cases where not directly dismissed by decrees, but dismissals based on decrees, the Constitutional Court required labor courts to examine the substance of the case to enable applicants to access to justice. This will be not the case in decree cases, because they already have access to administrative courts. The question for the Constitutional Court will be whether the Constitutional Court will find the examination that has been done by the administrative court sufficient according to the Constitution and the Convention. We don't know yet. it might say that, okay, this type of examination does not meet the requirements of Article 6 of the Convention. But what we know is that these requirements will be assessed under the civil limb of the article, not criminal limb, because the European Court already found that against the third-party intervention, we together with Ayşe wrote that this was a civil case, not a criminal one. And myself and I know Ayşe also think in a similar way. We think that this is a criminal sanction. So the criminal guarantees of Article 6 should have applied to the cases of dismissals, but it seems that the European Court does not share our view, and I guess when the Constitutional Court will have to decide on this, it will decide similar to the European Court of Human Rights. So, I mean, from the Constitutional Court's side, I'm not positive either.
Thank you very much. We are approaching to the end of the panel. I mean, we will receive questions from the audience, but maybe one last question we could discuss. And this is about the Council of Europe. Why do you think the Council of Europe bodies made this recommendation to establish an ad hoc commission in the first place? They were very well aware of the concerns surrounding the independence of the judiciary in Turkey. And also what strikes me most is that Venice Commission, for instance, reported that the way the dismissals were carried out made it as ex post facto examination virtually impossible. But still they made this decision, recommendation, and the Venice Commission also endorsed this recommendation by the Secretary General of the Council of Europe. So what kind of a message does the Council of Europe to Turkey give with this recommendation and the subsequent decisions as judgments of the European Court of Human Rights? So it's a big question, but it's a kind of concluding question. And we can start with Ayşe, yeah.
I think that it was a huge crisis. It still is, you know, how to deal with what is going on in Turkey. And in a way, I think it was the European Council organs' attempt to defer the situation to somehow to back to Turkey, not to having to deal with it or so. So I think that's one of the aspects of it. Of course, it has lots of it has links to the general perception on human rights in the current times, the developments we see in other European countries, in the US and elsewhere, and what function those oversight mechanisms should have and should not have, this discussion around it. And as I said, for the European Court, for example, the fact that the court was going to have to hear tens of thousands of cases was enough for them to try to find ways to stop that happen. And the practice of the commission, there have been some other examples, not the same as this one, but there have been some examples of similar ways the court to somehow pressure the country concerned to establish a mechanism internally, so that many applications pending before the court to go back to that place. For example, we saw it in the enforced displacement of Kurdish people from the southeast in 1990s. Many applications before the European Court were found inadmissible after Turkey established a compensation commission in relation to those displacements took place. and that, you know, I know that process is still ongoing. It started in 2003 and 2004, and I know that there are still cases pending before the administrative courts, pending before the constitutional court, or so. And same happened in relation to Cyprus, and same in relation to, for example, Turkey's about that length of the hearings, the judicial procedures in Turkey, or, you know, the procedures that take so long. There are practices of Commission. But I think the failure of the European Council institutions to see properly analyze this was that, first of all, the other examples, although not the same, they didn't work well, because once those cases were referred back to the domestic courts, the applicants, those people whose rights have been violated, were left again alone with the violators, without any continuance of that oversight. Was a very wrong decision to make. The court or the Council of Europe institutions could have adopted a different approach. Even one agree with their concerns in relation to that. And second of all, I think that these cases are much more different, much more challenging, and it required a due considerations, and unfortunately they failed to do that so far.
I will add just one thing from the end, not from the beginning. Sometimes it's not meaningful to seek for a rational explanation, I guess. Therefore, I will quote a paragraph from Pishkin judgment. This is why I'm saying I'm talking from the end, not from the beginning. In paragraph 207, I quote, the court says, in the instance case, the court notes at the outset the general character of the wording of section 4.1g of emergency legislative decree, with terms such as belonging to and affiliated or linked with an illegal structure. It should also be noted that the government did not cite any criteria concerning the definition of the concepts mentioned in that provision. Moreover, the court takes note of the Venice Commission's considerations on the foreseeability of the criteria used to assess a person's links with an illegal structure. After saying this, and I don't know why it's saying this, because it doesn't respond, it goes on and say, nevertheless, the court takes the view of that. I mean, you know that Venice Commission said a opposite thing. You know that the government cannot explain, cite an example for this, but you still say nevertheless. I think this is, I mean, legally there is no rational explanation, but practically, as Ayşe said, the court knew that it doesn't have the competence to cope with tens of thousands of cases. In any case, it had to send back those cases. It doesn't matter whether to a commission or a court, but commission is better because this is another statistical information. The number of people is decreasing in every stage. Only 80% of people who got decision from the commission applied to the administrative court. Against the decisions of administrative courts, only 60% of them went to Court of Appeal. I don't know the figures, but I think it's even less are going to Council of State, and even more or less will go to the Constitutional Court. So at the end, even if some people still are resistant and decide to go to the European Court of Human Rights, it will be around 1,500, 2,000 rather than 120,000. I think this explains the inconsistency of the court, unrational explanation of why it's not seeing this as a problem, and why Council of Europe recommended Turkey to solve its problems inside Turkey. But I think this was a mistake, by the way. It created other problems now we face in Kavala and Demirtaş cases. I mean, if you don't address rule of law problems in a country, then it's like a boomerang, turns back and hit you. Now they don't know what to do about Kavala and Demirtaş, and others are pending before the court. 600 judges and prosecutors detention cases are pending before the court. What are they gonna do with them? The Constitutional Court already stated that it would not implement the judgment of the European Court of Human Rights. I mean the Baş versus Turkey case, because it states that the European Court cannot interpret domestic law better than the Turkish courts. So at one point you will stuck, sooner or later. It's not in the dismissal cases, then detention cases, or in freedom of expression cases. So I think rather than trying to defer the things to Turkey, at one point, the Council of Europe will have to decide how to address rule of law crisis in Turkey. And I think we're very close to that point, unlike what we had in Zihni, in Köksal and Çatal.
Thank you very much. Do we have any question? I don't see any question from the participants yet, but
yeah, you can write on the chat.
if there is none, I have one more question. Can I ask? Yeah, maybe until we receive a question, we can ask some more questions. I really wonder the impact that the reports you wrote. Kerem, you wrote a report at the very beginning of the process, even before the commission became operational. I know the impact of your report. Unfortunately, it was ending with a conclusion that invited the European Court of Human Rights to make a ruling as soon as possible without waiting for waiting for the actual practice of the commission. And unfortunately, it was not, of course, responded. But Ayşe, the Turkey Litigation Support Project and also Amnesty both wrote reports on that focused on the practice of the commission and powerfully shown how impossibly effective remedy it was. So did you receive any feedback from the Council of Europe bodies? I checked the report, 2020 activity report of the Commission, and they say that every year, at least once, they had regular meetings with the delegate from the Council of Europe and the European Court of Human Rights. For instance, civil society actors have they such opportunities to discuss their findings with the Council of Europe bodies as the state institutions could do?
We did send our reports to the Council of Europe, EU and UN institutions that are relevant to what is happening in Turkey. We didn't receive any kind of feedback or like reflection to the findings of the report. But as you mentioned, the Commission seems to be holding regular meetings with the Council of Europe, with the ECHR even. And we hope that those findings are raised with the Commission. For example, you know, the percentage of the decisions that are accepting the applications or rejecting applications, the acceptance rate was much lower when we were first working on it. But now it seems that it's above 10%, and I think the criticism towards this had some sort of impact on the course of the Commission. But what the idea of us to work on that Commission report was the fact that, you know, through our discussion with the stakeholders, building evidence for potential cases in the future or potential discussions on that matter between the oversight mechanisms and Turkey. And since, you know, that vicious circle of trying to resort domestic remedies, exhaust domestic remedies, is still ongoing, we don't know whether that will, you know, we don't have any example that would kind of, the court, for example, would reflect on the reports written on the commission. But I think it's important to continue doing that. For example, as we discussed, we don't have much information on what is happening between the administrative courts, for example, after the commission. Again, building that evidence for the future handling of these cases is important, and therefore the reports, I think, feel a gap in relation to that, and it should continue. On the other hand, I think it might be a time to discuss about a strategy to shape up maybe new cases that could be again brought before the ECHR or maybe the UN Human Rights Committee on the basis of what we have been discussing. And there are, you know, the grounds we discuss are of course legitimate grounds, and I think it is worth starting a discussion, if we haven't started yet, on what to do, what strategies to adopt on the situation that we are still waiting for years to pass for these issues to be addressed properly.
Ayşe, maybe we can add our third-party intervention in Pishkin case. ICJ and Turkish Litigation Support Project jointly intervened in this case, and the parts where the court examines the criminal link discussion is based on third-party intervention. So in a way, we received a response from the European Court of Human Rights, unfortunately not a positive one. And in Baş versus Turkey, this time for the criminal peace judges, the court in details examined the impartiality of the criminal peace judge system, and unfortunately we failed in that one as well. So, but still I think it's important to draw the attention of the court to the problems from the field in third-party interventions. Maybe not worked very good in two cases, but still the court feels the shadow of civil society through third-party interventions.
Thank you very much.
We have a question. Should I read? So Stefanos asked, is legal aid available for those wanting to pursue their case before the Commission, the Administrative Court, and the Constitutional Court?
I mean, for the Commission, as far as I know, no legal aid is provided, and no, it's not needed. It's a very easy process. But for the Administrative Court and Constitutional Court, usual procedures for legal aid work. So if you can prove that you're in need, both at the Administrative Court and Constitutional Court, courts might decide to grant legal aid to, I mean, this is not a legal aid like providing legal support. It says, it means that you don't have to pay the court fees, I mean. And I understood the question in that way. So legal fees might be exempted if the applicant can prove that financially that person needs that support.
So to make it clear, maybe not for instance, to have a legal representative.
Yeah. Not to appoint a legal representative, but to exempt from legal fees before the courts.
Okay, and also
this is not a criminal case, so in civil cases there's no requirement to provide a free lawyer to the applicants.
maybe just a little note on that could be, although it would be very hard for Ankara Bar, for example, to entertain all the applications, but I think the bar associations have some sort of legal aid scheme that could be tried, but in such vast number cases, it would be impossible for the bar to, of course, because the cases will be heard in Ankara. Administrative courts would be very difficult to entertain applications made to it if applications are made to the bar.
We have another question. Al-Reza Çoban is asking, could you please more comment on the definition of the Constitutional Court and the Council of State dismissals as extraordinary measure rather than criminal or disciplinary sanction and its impact on burden of proof?
I mean, it's a very good question. I mean, of course, if it was a criminal case, then the prosecutor should have proved beyond reasonable doubt that that person committed a crime. And it would be very difficult to prove. And in cases where only social environment information was used for dismissal, most likely that the prosecution would fail in proving this. By calling this as an extraordinary measure, it seems that both Constitutional Court and Council of State wanted to leave these measures in the gray zone. So we don't know the standard of proof in those cases. But so far, the examples that we see show that there is no threshold for evidence in the review of dismissal cases. That's why, yes, it's important. I mean, there is no category in Turkish law, this extraordinary measure. It should be either an administrative sanction or a criminal one. So at least we should assume that this extraordinary measure should be equal to disciplinary sanctions and should be subject to the requirements needed for disciplinary sanctions. But as I said, by leaving these measures in gray zone, Constitutional Court and administrative courts paved the way for arbitrariness. And it has been the case rather than proof standards.
Okay, so we are almost at the end of the panel, and still I'm looking into the chat box. Please feel free to write. But Esra, we're talking about the panel questions, and I think our last question would be that because what you described, what we know is a kind of a judicial legal maze, not to exhaust the possible remedies, but the exhaust the hopes of people while they are running in the maze and finding a solution. So is there still a way out of this mess created by the state of emergency measures?
Before giving Ayşe the word about this maze, I forgot to say, with the same law, the examination of the cases of the judges and dismissed judges and prosecutors were left to Council of State. And since the first dismissals, it has been more than 4.5 years for the judges and prosecutors. And so far, only in 2 cases, Council of State delivered judgments. So more than 4,000 judges and prosecutors are waiting before the Council of State. So we can figure out how long the dismissed public servants are supposed to wait before the Council of State. So this maze might be more complicated than even we think, Ertuğ. So I think this is the answer of your question, my answer. I can see a way out from this maze.
It's very hard not to agree that it is indeed a maze and it is still ongoing. You know, it seems like there are lots of challenges, especially if the European Court and other oversight mechanisms continue to stick on their approach against those cases. There has to be a change in their perception or their willingness on how to deal with that. And I think this would be partially possible if enough pressure could be made on those institutions, right? And this should be always, I feel like always a part of our work, you know, how to exert more pressure on these institutions to show them what is going on, and this very serious situation affecting lives of thousands of people. You cannot turn your back and ignore the fact that you have to deal with it. There has to, a way should be opened for that. And that's why when I was mentioning it, I think, you know, there could be work, a kind of strategic discussion we could carry out with other stakeholders or people who are thinking on this matter to see whether we could shape something and a new group of cases based on the developments so far and still appeal before the ECHR or the UN Human Rights Committee. So we need to discuss, we need to talk about it. And another side of it, I would say, Kerem mentioned how disappointing Pishkin judgment was, which I agree, especially that during our research on the third-party intervention, we kind of, you know, we put forward a very strong case before the court that you know, trying to give some information, some direction on how the approach should be to those cases, but the court unfortunately didn't do that. I checked it yesterday. Pishkin is still not final. It's so we will wait for it to become final, or maybe there will be a referral request to the Grand Chamber. We don't know that yet. Depending on that, if it becomes final, I think it's important to still create an advocacy around that case and try to use the Committee of Ministers review of execution of judgment process to have the committee accept some aspects that we have been arguing and put pressure on Turkey as a way of general measures to implement this judgment, to take measures to ensure those processes that may somehow will be resolved. I think these are some ideas that I could share on what we could do.
Thank you. I fully agree, by the way. A great idea.
Okay. Esra, do you have any last words? He's not here? She's not here? Oh.
She might have similar technical issues that I had. Maybe.
So I think maybe this is a divine intervention. Thank you so much. I don't want to, you know, end without Esra, but she's now writing to me that the internet is gone. Then there is no further question from the participants. So we really, you know, full-heartedly thank you, your time and your work in this difficult subject that we learn, and hopefully we will continue to learn from you and collaborate in the same way that you are leading us in terms of the Ayşe's and your comments for to at least maybe find way or collectively find way out of this maze. So thank you very much, and thank you for everyone for joining us tonight.